Good morning, everybody. So today for this session, I was planning to spend most of our time today reviewing these items that I've listed here. The knowledge checks, I want to go back over the, just primarily focusing on the questions that people got wrong and skimming over the ones that it seems like everybody understood. And also spend some time looking at an old exam, just to give you a flavor for what you're likely to run into on the exam next week. I assure you that the exam next week won't be identical, but it will be similar. And then we'll go through any questions you have about the assignments that are due tonight. Before I dive into that, does anybody have anything they want to talk about right out of the gate? You guys good? Anybody online have anything they want to talk about? Anything to add to this agenda? All right, it's being recorded, so of course I'll post it when we're done. So if you feel the need to scribble furiously as we go through these questions, know that you'll have the benefit of the recording. So, all right, well, let's start with the knowledge check from quiz 1. I think people did relatively well on it. The average score was 92%. And maybe the first one was the one that people had the most difficulty with. Which of the following is not an estate planning goal? Anybody want to take a crack at explaining why maximizing the gross estate is not an estate planning goal? Sort of seems like, gosh, when you're in financial planning, you'd think that you want to help people accumulate a lot of assets. But why is it that maximizing the gross estate isn't a goal? I'll start picking on people. It's not, I'm gonna make it fair. We're gonna start at the top of the list. I'll start with Ben. Ben, why do you think that maximizing the gross estate is not an estate planning goal?
I'm not too sure about it.
What happens if you have a big estate? What if we manage to maximize the gross estate and puff it up to, let's say, $30 million? Have I done my job if I help somebody maximize their gross estate? Because it means I've died. If I have a big estate and I've died, what's going to happen?
More tax.
Yeah, exactly. So isn't my goal really is to help them minimize their transfer taxes? So that second one sort of gives us some clues as to why maximizing the gross estate isn't an estate planning goal. It's to help the client meet their financial planning objectives. I suppose you could say if one of their objectives was to pay a lot of estate tax, then maximizing the gross estate is a goal. But generally, it's not considered to be the goal. You're trying to help them achieve their estate planning goals, and typically minimizing estate taxes is one of them. Thanks for taking a crack at it, Ben. I assure you everybody will have a chance to guess. Okay, as a financial planner, you're preparing for a meeting with a new client. What would you most likely ask Jorge to bring to the meeting? I think most of you knew that will and codicil is what you'd probably have them bring. Sales records for his business aren't that helpful for a financial planning meeting. It might be one of the things that you have them bring, but the most important thing on this list is the will and codicil. Okay, although he has a vast fortune, Tricky has decided not to prepare an estate plan because he believes that his surviving family members will divide up his assets appropriately. Which of the following is not a risk associated with failing to plan an estate? Well, I think these are, when they're worded this way, it's very tough. It makes you like take pause. And what we're looking for are, let's identify which of these are risks of failing to plan. Tricky's estate could incur excessive transfer taxes if he fails to plan. That's true. Tricky's insurance policy on his own life may not be paid out to the named beneficiary. Well, failing to plan an estate, if he's got a named beneficiary, that shouldn't be a risk. And so the rest of these, his favorite car may not be transferred to his ex-wife, Carla. That's a risk because she's his ex-wife. And she doesn't naturally have any intestacy benefits if she's not currently married to him. This one people seem to get right. Which of the following activities would be considered the unauthorized practice of law for a financial planner who is not a licensed attorney? So this seemed pretty straightforward. Obviously, preparing a will for a client is not an acceptable activity for a non-attorney. You're going to see in the exam a more complex application of this question. And we'll expand on it because I feel like this is a big question, not just for students, but for financial planners who really don't understand what they are and are not allowed to do, what is considered practicing law and what is not. People generally understand this. Which of the following advisors are qualified to give estate planning advice? There's a lot of generally understood principles that we are all allowed to speak to if you've got some education on the topic. All three are allowed to give estate planning advice. And estate planning is an important aspect for which of the following? Probate and succession planning, comprehensive financial planning, and retirement planning. So some people felt that retirement planning wasn't a part of estate planning. Jake, I know that you probably anticipated you're going to be the next one I was going to pick on in this list. Do you want to take a crack at why retirement planning is on the list along with probate and succession planning and comprehensive financial planning? Why is estate planning an important aspect for all three of these, including retirement planning?
Yeah, I kind of struggle with that one. I would just assume that retirement planning kind of takes comprehensive financial planning, and also with a lot of people's goals that they want to leave assets to their heirs. So that would be estate planning would go well with retirement planning.
No, I think that's right. I think that one of the biggest challenges I face with clients who want to give their kids a lot of assets, I'm dealing with it right now. I've got a client who wants to pay for all three kids to get advanced degrees, and two of them are in medical school right now. And, and he'd love to leave them a large estate and start gifting them all sorts of money right now. And frankly, he doesn't have enough money for retirement. So in order to help a client understand what their gifting options are during life and how much is going to be available at death, you have to work through their entire financial plan. And you're right, it was sort of a giveaway because comprehensive financial planning generally includes retirement planning. And so anyhow, that's why retirement planning should be included on the list. The best definition of estate planning is a plan for managing property during lifetime and death. It's not just planning for the disposition of your assets at death. It's kind of a commonly assumed reason for estate planning, but you're trying to manage your assets even before your passing to make sure that you're managing them effectively so that you can achieve your goals. Failure to have an estate plan can lead to all of these, like 100% of you got that right. Good job. All of the following are transfer costs associated with estate planning, except, ooh, this is a tricky one. Okay. So attorney's fees for documents are costs associated with estate planning. You know, when you have to, you know, when you need help, when you're managing an estate, you're going to have to pay for the assistance of an attorney to help you get through the process, oftentimes. And the cost for retitling assets, including real estate, that is a transfer cost. When we say transfer costs, we're talking about the literal expenses that you are incurring as part of dealing with someone's probate estate and the rest of their estate. The moment somebody passes, you've got all this work to be done. And much of that work includes paying fees for people to help you, fees for the cost to transfer title from one person to another. And it's being paid for by the estate. It's not being paid for by the personal representative, right? But these are costs associated with estate planning. Estate and inheritance taxes, everybody understood that one. But property taxes on inherited property, why is that one not considered a transfer cost? What are we referring to when we talk about property taxes on inherited property? Kyle, I bet you're excited for this one. It's yours. Want to take a stab at it? You're stumped? Is that what you said?
Yeah.
Then let's get, let's see, who can we get to help you? Anybody want to volunteer to assist on this one? Bailey or Thomas, you want to take a shot at it? Well, that's true. Bailey said, so it's because it's not something that the decedent has to pay. Property taxes on inherited property. I own a house right now. At the end of the year, I have to pay property taxes as a result of my ownership of this property. It helps to fund all sorts of things, police and fire and schools and whatnot. The mere transferring of that property from one person to another does not trigger a property tax bill to be due. Eventually, the person that inherits that property will have to pay it, but it is not an expense of the decedent or of the estate. So it's not considered a transfer cost. It's a little bit in the weeds, but it is what it is. Okay. You as a non-attorney CFP are asked to assist one of your clients who's very frugal to prepare a will using LegalZoom. Which of these is correct? And the majority of you got it right. You can't assist her. What you can do is help her prepare for the meeting with an attorney. I just sat through a presentation yesterday for a company called Helios, Helios. They are trying to be the nationwide estate planning provider for financial planners. And they want financial planners to help clients work through the questionnaire and have this company produce their estate planning documents for a fraction of the cost. One of the big questions is whether or not, financial planners will be comfortable doing this, but I think it has legs because ultimately these documents are being prepared by attorneys. And so there are some ways that you can help your client prepare for a meeting, but you cannot prepare the will itself. Okay, any questions on any of those? All right, let's move on to Knowledge Check 2, Basic Estate Planning Documents. Average score went down a smidge on this one from 92 to 89. And we begin with, this is a good one. The general power of appointment. Often misunderstood document because it's really an awkward thing to try to understand, but let's walk through these. First of all, let's define general power of appointment. A general power of appointment essentially means if you give me a general power of appointment over your assets, I have your permission to use your assets as I see fit. I can even use your assets to pay my own creditors, to pay my own bills. I essentially own you and your assets, right? I can do all kinds of damage to you with that general power of appointment. If there's any limit whatsoever on that general power of appointment, well, it's not a general power of appointment anymore. It's a special power of appointment. So when we look at this list, which of the following powers given to anyone would cause the power to be deemed a general power of appointment? The power to make gifts to the principals, heirs, and charities. Well, that in and of itself isn't a general power, it's a specific power. The power to use the principal's money, so the power giver's money, to pay the power giver's creditors, no, that's also special power of attorney, not deemed to be essentially giving your assets away. The power to use the principal's money to pay the power holders, so the agents, creditors. Well, that's bing, 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 bing. You have, if you are the power holder, you now have the ability to use the principal's assets to pay your own people. That is absolutely a general power of appointment. The power to sell and buy property on behalf of the principal. That is not a general power of appointment. One thing that it might be helpful is to try to think about if you were a scoundrel and you were trying to get around gifting rules, right? Let's say you're super rich and you want to find a clever way of giving your kid the ability to, well, giving your kid all of your assets during your lifetime, but you don't want to pay any gift or transfer taxes on it. You're like, well, instead, and you want to have the ability to take that power away right away. So instead of outright gifting to your kid, you decide, well, hey, I'm just going to give them through this document the right to spend my money on whatever they want. And then it's not considered a gift. Well, whoa. Yes, if you die while your kid has that general power of appointment in effect, all of your assets, well, I should say if your kid dies while they have that in effect, all of your assets will be in your kid's estate. Because that your kid had the ability to be using your money to be paying for their own stuff, including their own creditors. So a general power of appointment is a big deal, and you're going to see it come up more often in this book. Any questions on that one? Any confusing parts of that you want to drill back into? Okay. Making arrangements to deal with the possibility of physical or mental incapacity is an important area of estate planning. Which of the following arrangements may be used to deal with such unexpected incapacity? Most of you got this right, but number 3, I don't even think we've talked about, and I really can't hold you guys accountable for knowing what that is, but you'd have to have Googled it, right? Because a Q-tip is a qualified terminable interest property trust, which allows you to control from the grave who's ultimately going to get your assets using a trust. But we did deal with some of these other tools in this chapter. So a springing durable power of attorney allows you to plan for your own incapacity. So what does this springing feature mean? Lissa, I'm going to go to you next, even though I think this list keeps jumping around. But why don't you take a crack at what does it mean for a power of attorney to be springing?
I'm not positive, but is it when it's more flexible?
Well, in terms of flexible, I don't know that I would use that. I don't know that I would say flexible with springing, except I guess flexible if you wanted to limit when it went into place. Anybody want to help What can you say about springing? How about Lauren? What do you know about springing? What do we mean by springing when it comes to powers of attorney?
Is referring to it comes into effect upon a certain event. So if the person holding it were to become brain dead or something like that, some specific event, then that turns on.
Yes, yes. It's like you could replace that term springing with the word trigger. A triggerable durable power of attorney, right? Or a triggerable power of attorney, period. So it springs into effect upon whatever event you want to put in place, right? And yes, usually it's your own incapacity, which means like right now, I have a springing power of attorney that I signed to give my husband the right to make decisions on my behalf. If I'm not able to myself, I'm not going to give that away while I'm perfectly fine, right? Now, if I'm far too busy, if I'm just like the super busy person and I can't be bothered to make my own decisions, then maybe I'll have a power of attorney that's in effect right now and it doesn't spring into place. It's like good now. But durable, what does the durable feature mean? So we've covered the springing. What is durable in this setting? A durable power of attorney. How about, let's go to, who's next on the list? How about Milo? Milo, you want to try to tackle the durable feature? What do we mean by that? If not Milo, how about Nick B? Nick B, can you help us with the term durable? What is that referring to?
Does that mean that like less than the person's incapacitation?
Yes, it means that that's the whole point of it usually, right? It's like this power of attorney is durable, meaning if I'm incapacitated, it's still in place. Now, here's a quiz question. When for sure does a power of attorney end? Any of you want to take a guess? When does a power of attorney for sure come to an end for everybody? Oh, I see it in the chat. Yes, at death. So no power of attorney can survive death. Otherwise, you'd continue to walk around through someone else, right? But what can survive your death? What have we talked about today? What power can you give away that can survive your death? Dun, 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 dun. Power of appointment. Remember that the power of appointment can survive your death because you might need your trusted person to make decisions for you about where your assets are going to go after you're gone. You have no idea 10 years after your death what's going to be happening with your heirs. Maybe you'll want this person to cut somebody out of the from getting money because they're not being, I don't know, they're not doing what you wanted them to do with it, right? Or maybe you want them to be able to control how much is being doled out to, a former spouse, or maybe you've got a child with a disability and you have to be super careful about how much money they get because the rules change all the time about what assets a person is allowed to have and still keep some of their benefits. So that power of appointment can survive your death. But the deal-making power, the power of attorney, cannot. Okay, did I skip one? This one we should know. Oh, I mean, Okay, we just did. So revocable durable or springing durable, a revocable living trust. We're going to talk more about. I'm not going to hold you terribly accountable to understanding lots of details about that, but that can be used to deal with your incapacity. Because your assets would be titled to the trust, it allows for your trustee to manage your assets in the event that you become incapacitated. And a living will is important because we need to know what your wishes are. If you have something really, really bad wrong with you, we need to know what kind of life-saving measures you want performed. But the Q-tip is different. It doesn't have to do with your incapacity or physical or mental incapacity. So this question is trying to get at what are the different chunks of, what would you expect to see in a will? Josephine, who single drafted her own will using Zoom Wills, she sends it to you for your review. In your first review of the will, you look for which of the following common provisions. Well, this, I'm not going to put a question like this on the test because I really don't feel like you are not going to find yourself in a position to be judging the quality of a will as a financial planner. What you will find yourself doing is making sure that they have a will, and you will read it to see who they're giving things to make sure that their wishes that they have in the will are consistent with what they've told you they want, and to have you consider sending them to a lawyer to have it revised if it appears there's any inconsistency whatsoever. So a statement of the domicile of the testator, sure. I mean, a specific bequest of property owned joint tenants with rights of survivorship, that's not going to be in the will. You title something joint tenants with rights of survivorship, so you can avoid it going through your will. A self-proving clause and a simultaneous death clause. Those can be parts of a will, but a statement of the domicile of the testator absolutely would be in the will. Here we go again with this general power, with the question about a general power of appointment. Bill has a general power of appointment, ding, 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 which means that's a big deal. He can appoint those assets anywhere. He has a general power of appointment over all of his father's assets. Which of the following is false? So Bill can appoint his father's money to pay for the needs of his father. Well, that's true. He can do that with a general power of appointment. If Bill predeceases his father, Bill's gross estate would include his father's assets, even though they have not been previously appointed to Bill. That is also true. We're looking for the false statement here. Bill can appoint money to his own creditors. Yeah, that's the thing with a general power of appointment. Knock yourself out. Bill must only appoint money using an ascertainable standard. No, that's bull. He's got a general power of appointment. He doesn't have any limitations. That's why that one's false. Questions on that one? For extra marbles, when we talk about ascertainable standard, do you remember the acronym that we talked about that is often used to create this ascertainable standard? It's it's 4 letters. In the acronym, because there are 4 things that are often put, yes, HEMS. So the acronym HEMS is related to this ascertainable standard and is buried inside of these powers of appointment to prevent the power from being considered a general power. Does anybody remember what the H stands for? Well, first of all, let's define this. When we say ascertainable standard, we're saying, look, Mr. or Mrs. Power of Appointment holder, you can appoint assets, but only for these reasons to these beneficiaries. It has to be for their, what's the H stand for? Health. Very good, Carson. What does the E stand for? You're all getting one right now in theory. education. Thanks, Lauren. What does the M stand for? This is my favorite. These last two actually I love because they're so generic. M. What does the M stand for? M and S, put them together. It's sort of the same thing. What do you do to your car's engine? What do you do to your lawn? Maintenance. Yes, thank you. And what's the S? Rushil, what is the S? Support. Carson helped you. Rushil, thank Carson. So support. So these are the ascertainable standards that you're going to see. You're in 5 years, you're going to be reading some boring trust document and you're going to see HEMS and you're going to chuckle to yourself because we covered it. It's everywhere. Health, education, maintenance, support. There's all sorts of goofy things that you're going to see buried in trusts to try to get around rules. And this is one of them because most people want to avoid a general power of appointment if they can, because it's riddled with landmines. Okay. Harold, a non-attorney, prepares his own will. He handwrites all the provisions and signs it and dates it, but fails to have it witnessed by anyone. What type of will does he have, if any? He's got holographic will. My trick to remembering holographic is handwritten, the H's, holographic handwritten. Non-cupative, can barely say it. That's why it's a spoken will. So statutory will is what most of us want. I think you all should understand dying intestate like nobody's business, because essentially it's dying without a will, right? Now, understanding what makes for a valid will, yes, the decedent handwrote a will that was signed but was not dated or witnessed. That is not a valid will. I don't really like test questions about those things because I think it's too picky and the laws are too different from one state to the next. Key parties to a power of attorney. Here's I'm gonna have somebody tell me what's the difference between the principal and the agent? How would you describe the principal and how would you describe the agent? If you had to explain this to a client, who's the principal, who's the agent? Milo, I'm coming back to you just to make sure you're okay.
Yeah. Oh shoot. It's feeding. Okay. The principal is the person who is giving the power of attorney, or the person who is the one that would be acted for, and then the agent is the one who would do the acting or act on behalf of the principal.
Perfect. So if you're the professional tennis player, you're the principal and you hire an agent to represent you, it somehow can be easy to remember it that way. At least that's how I think of it. And the rest of these key parties to a power of attorney, no. The rest of these just the attorney who prepares the power of attorney, no. It's that helpful person, but they are not the parties to the power of attorney. Okay, an attorney prepares a will for Joe in which Joe leaves everything to his wife, Carmela. Joe's neighbor, Vicky, is one of the witnesses to the will, and his close friend, Jack, is another witness. Which of these people is the testator? It's the person who wrote the will. So, and codicil, you guys got that right. If I would have put side letter of instruction, I bet this would have I would have been able to draw one of you away from the right answer if I would have added that to this list. And just know that a side letter of instruction is nothing more than a yellow Post-it note that you're throwing on top of the will, just saying, please cremate me, or, put me in the blue dress or whatever. It is not a part of the will. It doesn't modify the will. It is just simply your little note to whoever's in charge for things that you want done right away. And you don't want to wait for the will to be proven to be valid for these things to happen, because that could take months and you don't want to be on ice for months. When Ron died, he held a power of appointment over a piece of property under which he could only appoint the property to someone other than himself, his creditors, his estate, or its creditors. What type of power is this? I mean, this power of appointment is going to haunt you, so I want to make sure that you understand this. So since his power was limited, he could only appoint the property to someone other than himself. Well, then you know the moment you read that statement, it's not a general power of appointment. Because a general power of appointment would not have these limits. He would be able to do whatever he wanted. So it is a special power of appointment. Power of property appointment, no. All right, any questions on any of those? Okay. Let's go to '95. You guys crushed this one. Just crushed it. So this might not take as long, but let's just see. Because of the topic, though, types of property and interests, this is up there with things that you will use. Oh, you'll use this in life. You'll use it for your own life. You'll use it in your work life. This is very helpful. So when a decedent's property, when would a decedent's property be subject to ancillary probate? All right, this one won't come up often in your life, but you'll know, because someday you'll be buying real estate somewhere other than the state that you live in, and you'll be like, oh, hey, that's right, I'll be subject to ancillary probate if I'm not careful. You could avoid it by titling that piece of property to a trust, but if the decedent is a tenant in common in real estate with an unrelated person, and the property is located in a state other than the state of domicile. So here, what's tricky about this one is it's 2 layers. You have to know, one, that we're talking about probate assets. So you have to be thinking, all right, what would trigger the need for something to go through probate? And then, oh, by the way, also what would trigger it to go through ancillary probate? So you have to know that ancillary means a state other than the state that you are domiciled in. And then you've got to be smart enough to know what assets go through probate and which would just transfer directly, right? So it's 2 layers here. Now, one person got tripped up by this LLC interest, which is understandable because that's a terrible herring to throw into the mix, because it's possible that that LLC didn't have an operating agreement, but if it did, then, you know, if the decedent is a resident of one state and owns a real property interest in an LLC in another state, that one is, I could see how somebody would get tripped up on that. If the decedent owned a life estate in real property located in a state other than his state of domicile, why is that one not correct? What is the trigger in this option? If the decedent owned a life estate in real property located in a state other than his state of domicile, why is that not a probate asset? Who wants to take a crack at that? What's the key there? Nick T, what do you think?
Not sure what a life estate is, but that's going to be the key.
You're right, it is the key. So if I give you, I've got this great cottage in Wyoming. You're gonna love it. I never use it. I don't know what I'll do with it, but you love Wyoming. So I'm gonna give you a life estate in that cottage in Wyoming, and you get to use it until you die. And then I get to decide where it goes after your death. That's a life estate. Oftentimes life estates are used to give somebody you care dearly about a place to live until they're gone. And they have the right to stay there until they're gone. So this would oftentimes be used with in second marriages or in second relationships. I have a client who is, she's had a long time. I mean, she's in her 70s, her boyfriend's in his 80s. They've lived together forever. She's got kids from a previous marriage. She wants the house they live in, her and her boyfriend. She wants the house that they live in to ultimately go to her kids because she bought it. And her boyfriend in his 80s is essentially out of money. So if she dies before the boyfriend, she wants to give her boyfriend a life estate in that house so he has somewhere to live. Her kids are nice, but she doesn't want to trust that they won't give him the boot, right? So she needs to give him a life estate to be certain that he will have a place to live until he dies, but he does not control that asset. So upon his death, it doesn't go through his probate estate, subject to his will. He's got a life estate. It comes to an end. It reverts back to whoever she indicated as an ultimate beneficiary, which is her own kids. Does that make sense? Okay. Any other questions on this set of options? I don't think anything else isn't that is tricky. All right, which of the following states is not a community property state? I know, since it's open book, I guess I could throw this in there. I just don't expect people to memorize. I do expect you to know that if you are in the practice of working with clients, you're probably going to need to be aware that you have to ask them some questions about where they've lived before if you want to understand whether or not they're subject to community property rules. If you're going to practice in Wisconsin, then you absolutely need to know Wisconsin's community property rules. You guys had this one, but I'd love for somebody to explain it to me. I can't believe we got 100% correct on this. Actually, maybe it's the next one that I couldn't believe. But so this is the type of question that will come up on a test. Teresa and her brother Michael decide to purchase a condo together. They want to use it for family vacations. I mean, first of all, we know they're not married, which is oftentimes the tricky part of some of these questions. So A, they're not married, they're brother and sister. Okay. They want to buy a piece of real estate together. The condo is $620,000. Michael expects to use the condo 60%, Teresa 40. Michael contributed $372. Teresa contributed the balance. Their ownership percentage equals their contributions percentage. We know right out of the gate what are some of the triggers here that tell us what they can do in terms of property titling. Well, first of all, why can't they title it community property? Is it Lissa or Lisa?
It's Lissa. It's Lissa.
Lissa. Okay. I thought I'd flush you out that way. Thank you. Why can't they use community property titling?
Because it's community property during the marriage.
Awesome.
And they're not married.
You got it. Thank you. And Carson, why can't they use tenancy by the entirety? Thomas Helper, why can't they use tenancy by the entirety? Yeah, also have to be married for that. And why can't they use joint tenants with rights of survivorship? Kyle.
Ownership percent.
Yes, because joint tenants with rights of survivorship is automatically equal ownership. Now, if you brought lumpy amounts, that triggers a different issue, but they want to have the titling reflect their ownership interest, and the only thing on this list that gives them that option is tenancy in common. Cody and Chelsea married. They have a home, title community property, which, by the way, sometimes you don't have community property rules apply almost no matter what. Almost doesn't even matter how you have it titled. They purchased it as community property is the key there. Because you can sometimes have somebody in a community. Think of how many people are running around Wisconsin right now. They have no idea they're in a community property state. It's not like the moment you're married, they make you take a test to like prove that you understand what the heck you're doing, right? When it comes to, well, pretty much anything, but especially when it comes to property titling. You've got people who are buying pieces of property while they're married, titling it in some goofy way that they think is fine, but they're going to learn that community property rules are king. So even if they purchase something with someone else, their spouse is an automatic owner in that piece of property. Anyways, so they purchased the home 3 years ago for $200,000. After improvements and a surge in the market, the home is now worth $400,000. If Cody died today and left his share of his home to his daughter Alyssa, what is Alyssa's federal income tax basis in the house? Well, you all got this right, and you said 200,000. What's Chelsea's federal income tax basis in the home, in her half of the home? So they purchased it 3 years ago for 200,000. So they each had a cost basis of 100,000. After improvements and a surge in the market, the home was worth 400,000. If Cody died and Chelsea keeps her half, what is Chelsea's cost basis? In her own half. Does it change? Does Chelsea's cost basis change in her half of the house when Cody dies? Rochelle, I'm coming back to you on this.
No, it doesn't.
Say that one more time.
It doesn't.
Well, the good news for you is if you decide to settle in a community property state and your spouse, well, and the sad news is your spouse has died. The good news is you get a step up. It's a weird rule about community property that if you own something as community property, meaning you own your half, your spouse owns their half, the moment either of you passes, the other gets a step up in cost basis to whatever the fair market value was on the date of your death. That's going to come up. So I think it's worth reinforcing. Jack and Jill are not married and own farmland. Okay, not married, own farmland, titled as joint tenants with rights of survivorship. What do you know right away? Without going any further, what percentage ownership do they each have now?
Equal.
Yes, exactly. 50-50. Jack originally contributed 90,000 and Jill contributed 60,000 toward the purchase price. Huh, interesting. Unequal amounts, and they're not married. The land is currently valued at 800,000 and each of them has a 50% interest in the property. If Jack died today, what amount of the value of the farmland would be included in his gross estate? Oh, this is exciting because there's math involved. Let's just walk through it real quick. So Jack paid 90 out of the 150, which is what percent? What's 90 divided by 150? I'm pretty sure it's 60%, but anybody want to fact check me on that? Thank you, Lissa. So he paid for 60%. That tells us, even though, and that's the weird thing, if you're not married to the person that you title something, joint tenants with rights of survivorship, You've essentially given a gift, right, to the other person if you paid for more of it. And also, when you go and die, you're going to have that same ownership percentage in your estate. Even though you only owned 50, he's going to have 60% times the 800,000 or 480,000 in his gross estate, because that's what he brought to the table. Now, how would this question, what would the answer be if they were married? How much would be in his gross estate? Jake, how much would be in Jack's gross estate if he and Jill were married? Again, gross estate, not probate. Gross estate, Jack and Jill are married, entitled joint tenants with rights of survivorship. And it was worth, the whole thing was worth 800,000 when he died.
Would it in a community property state would 400,000?
Well, you got the number right, but there's nothing in here about community property. So we're just working off of joint tenants with rights of survivorship. And that alone is enough to tell us how much is going to be included in their gross estate, as long as we also know whether or not they're married. And if they're not married, then we absolutely need to know their ownership percentage. I could give you a test question that would say Jack and Jill are married, own a piece of property worth 800,000. We can't find the documents to determine who paid what for it. Can we determine how much is in Jack's gross estate? The answer is yeah, doesn't matter. Don't care who brought what to the table. He's going to have 50% be in his gross estate because they were married and it was titled joint tenants. But in this case of the question that we've got before us, they're not married. So we absolutely needed to know all of that detail about who brought what to the table initially. Questions on that? All right. Bob and Charles own a townhouse, not married. Charles brought 30%. Bob contributed 70%. Each of them has an equal interest in the property. Which of the following are permissible ways they could title the property? This looks awfully familiar. I mean, we essentially just did this. There's two people. They each want to have an ownership stake reflected, so sole ownership's not going to work. We can't do tenancy in common, or I'm sorry, we can't do tenancy by the entirety. Can we do tenancy in common or joint tenants with rights of survivors? Totally. This one tripped up a few people, so let's walk through it. Sherry purchased a home many years ago for $100,000. Later, she married Gary when the house was worth $200,000. Sherry and Gary live in a community property state. Uh-oh. Assume Sherry died today and left her entire interest in the property to her son, Cody. The property is currently valued at $400,000. What is Cody's basis in the home after Sherry's death? I wonder why do you think we had 5 people say 200,000? What were they, how did they get this wrong? What do you think their error was in coming to a conclusion on this? Lauren, do you have any guess? Why would somebody have said 200,000 instead of 400,000?
They probably assumed that gonna get half of the value.
Because they were thinking it was community property, therefore her husband was going to get half of it.
Yes. That maybe they bought it together, or he put some money into it.
Yeah. So the question tells us that she bought it before she married Gary. And we know that we can keep anything that we bought before the marriage separate. And so that's 100% her property. Now, you could ask some further questions. If you're a good lawyer, you'd be like, but wait, did they use any of their marital assets to improve that property? Because then maybe they spoiled the separate property water, and now it's been tainted and can be considered community property. But we don't put those details into this question. We're trying to imply that Sherry has this as separate property and that Gary doesn't really have any ownership interest in it because it was purchased before they got married. All right, Dennis died, leaving all of his assets in a trust for his wife. He was concerned that she would not be able to manage her money adequately to maintain her standard of living. Therefore, he placed the assets into a spendthrift trust and gave her the right to receive a certain amount of income each year. Dennis appointed his good friend Richard to be the trustee of the trust. How is Richard's ownership classified? So this was one of the questions from the muddiest points, just understanding the difference between legal versus equitable title. Typically, when you own an asset, you hold both legal and equitable title, but sometimes you can split it out. And trusts are one of those places where that happens, where you'd have, equitable title versus legal title. Equitable title, in this case, when you've got trust, the equitable title is the beneficiary. The legal title is the trustee. The trustee is calling the shots for the benefit of the beneficiary. The beneficiary still would receive all of the income from the trust. The trustee just essentially has the power to administer those assets. And therefore, that's the difference, legal versus equitable. A tenancy by the entirety is a property titling regime that exists between, you got this 100% right, way to go. So tenancy by the entirety and community property, spouses only. Four people own one piece of property. Which of the following forms of property ownership titling of those listed must they use? So we only lost one person on this question. It's funny because you would think community, you hear the word community, you're like, come on, it sounds like a party. We should let everybody in. No, it's a party between two people. Tenancy by the entirety, again, married people, that's not the case. Life estate, that's not going to work in this situation. They all own it. So tenancy in common is the only one. They could also list it. What's one other way that they could title this property? You and your three cousins are going to buy a cottage somewhere. Who have I not talked to recently? How about Nick B? If you and your four cousins or three cousins want to buy a cottage somewhere, what other title could you use besides the ones that are listed here? Besides tenancy in common, what's another way for you to hold title with four other people?
This is right. This is maybe like a term interest.
Interesting. Probably not. You wouldn't accept that if you were going to be an owner, though, because that term interest is a limited number of years that you would get to own it. It's a little tricky because the term, the phrase of the title might make you think it's just between two people, but who can help them out? What's another way that you could title that property with four people? That's a really bad cottage. Sorry. What do you got? Yes, Carson. Joint tenancy with rights of survivorship. Probably not the first thing you think of because you think joint tenancy, it sounds like it's between two people. But you can have a joint tenancy with right of survivorship with more than two. But what's the automatic ownership percentage in this case, Carson? So going along with you and your four cousins who are all enjoying this cottage together, if there's 4 of you, what's the ownership percentage? Yes, 25% each. Because it's automatically equal. Even if you bought the whole thing, you're so generous, Carson, you bought the whole thing, you brought all the money. Your ownership percentage during your life is 25%. But Carson, if you paid for the whole thing and then you went and died the next year and it was worth 200,000, how much of that whole asset is going to be in your estate if you paid for 100% of it up front? Yes, exactly. It'll be 200,000 because you paid for 100%. It's going to show up in your estate at the full value, if it's titled joint tenants with rights of survivors. Okay. Questions on any of those? Could work. Let's do. Oh, this is the one you just did. The probate process. Who wants to guess? I should take odds. What do you how do you think you guys averaged? Decent? Was it easy? It's probate. How hard could it be? 91. I think you did well. Okay. I cannot pronounce this name. Does anybody have anybody Norwegian that knows how to pronounce this? Is this Dagne and Ole? All right, never mind. We're going with Dagne and Ole have been in a long-term, non-married, non-traditional relationship. Dagne wants to make sure that if he dies first, Ole will be provided for. Which of the following would you be likely to recommend to fulfill Dagne's goal of transferring assets to Ole at Dagne's death? I mean, first of all, we're really focused in this chapter on how to deal with non-married, non-traditional relationships, especially if you want to make darn sure they get some assets, right? So transferring the ownership of Dagne's real estate investments to a tenancy by the entirety arrangement, why won't that work? Why won't that work? Why can't they do that? Why couldn't Dagne put it into a tenancy by the entirety? Not married. Thanks, Milo. Name Ole as the beneficiary of Dagne's retirement plan. I love that one. I love beneficiary designations. And the rest of these, advise Dagne against writing a will that specifically bequeaths assets to Ole. Sort of a confusing one because frankly, it's using a will to give somebody a gift. If it's at all controversial, you don't want to really rely on your will. But you're not going to advise against it necessarily. And recommend that Dagne and Ole move to a community property state. That would not. Community property and same-sex marriage have nothing to do with each other. All right, which of the following documents empowers an administrator to act as the agent of a probate court? Whatever. Letters of administration. This is not going to be a test question. This is a picky detail that I really need to remove from knowledge checks going forward. All right, which of the following assets will pass through probate? You guys nailed this one. Trust assets pass outside of probate. A pay on death account passes outside of probate. A life insurance policy with a named beneficiary passes outside of probate, but the death benefit or the cash value is absolutely going to show up in the gross estate, which you learned from this week's assignment. Which of the following is not a method to transfer property outside of probate? You nailed it. State intestacy laws. How did you guys do on this one? We tripped up 3 people. Kate owns the following property. Let's skip to the end. What is it going to ask us? What is the current value of her probate estate? So we're looking for probate assets. Is a personal residence titled sole ownership fee simple going to be in the probate estate? Yes or no? I saw a little bit of a head nod in the room. Anybody want to support that head nod? Is a personal residence titled sole ownership fee simple valued at $400,000 going to be in the probate estate? Yes, that's true. How about a $500,000 life insurance policy on her own life? The named beneficiary is Kate's brother, James, who died 6 months ago, leaving 2 children, Michael and Carol. Maybe this is the worst verbiage ever. It should have been made clear that her brother died before her. So if you have a life insurance policy, if I had a life insurance policy and I died, and my named beneficiary, when they go to find my named beneficiary, that person's died before me and there's no successor, then where does that life insurance policy go? Well, most of you know that it goes through probate because you answered this question correctly. So if we don't have a beneficiary that's living or that was alive at the time, so this is a little bit tricky. What if her brother James was alive when she died, but then 2 weeks later he died? When it comes to life insurance, would that benefit have been his if he was the beneficiary? The answer is yes, it would have been his. And then ultimately it would have passed according to his estate wishes. But in this case, we so far have 2 probate assets. Her home, because it was sole owner. Her life insurance, because her beneficiary died before she did. Why is that car not going to be a probate asset? Why is that car not a probate asset? Nick T.
Because it has rights of survivorship. Because it has rights of survivorship.
Yes, so it avoids probate by going straight to her mother. And that's the same case with the IRA. It's going straight to her mother. So the value of her probate estate consists of those first 2 items. Questions on those? All right. This is kind of an odd question. You're reviewing the group benefit for the group benefit plan statements for a married couple. They each have life insurance through work and they've named each other as beneficiaries. Their wills call for the establishment of a testamentary trust upon the first death. How should they proceed? We'll talk more about testamentary trusts in the trust section, but know that a testamentary trust is simply a trust that springs to life upon your death. You leave instructions in your will. I have this in my will. My will says, upon Lisa's death, create a testamentary trust for the benefit of her son. It's to be funded with life insurance. So I have life insurance benefits that will fund that trust to carry out my wishes that I've buried into my will for how I want that trust to be administered. But if I don't leave any assets to go into that testamentary trust, it's not going to do any good. It's like opening up a bank account, not putting any money in it. So that's why you want to discuss whether there's adequate funding. Joe appointed his son, Mike, age 30, as his power of attorney for all property. Joe recently passed away, leaving a sizable estate, which includes a number of investment accounts, real estate, and retirement plans. His will names his wife, Lisa, as a sole executor and calls for an outright distribution to her. Lisa's unsure if she wants this responsibility. What are her options? Well, the only option she has on this list that's within her power is to hire professional advisors to help her. She does not have the ability to tag out and name somebody else as the executor. She has the ability to tag out. She can just not do anything. But she doesn't have the ability to give power to Mike as the executor. She sure as heck doesn't have the power to establish a testamentary spousal trust because it's his will. And have Mike manage Joe's property under the power of attorney. He can't. The power of attorney came to an end when he died. So the only option here is to hire professionals. The only option that works here is to hire professionals. You got that one, perfect. This is the world's worst question. I know I say that to a lot of them, but this is true. What is wrong with this sentence? A person dying without a will is known to have died interstate. Yeah, thanks, Nick. It's like, if you skim it and don't read it out loud, you're like, there's nothing wrong with that phrase. So if you're a fast reader and you don't see the R, you might get that one wrong because it's intestate, right? And which of the following is included in a person's probate estate? Proceeds of a life insurance policy owned by the deceased with a named beneficiary is not going to be in your probate estate. It will be in your gross estate, but it will not be in your probate estate. Lifetime transfers by gift made by the decedent, generally not going to be in your probate estate. Retirement assets with a named beneficiary, nope, not in probate. So of this list, only a closely held business. Okay. So I had promised that we were going to discuss the old exam review, which maybe what I will do is cover that separately. Maybe on Monday we'll do that. Anything that you want to talk about regarding the assignment that's due tonight? Or assignments. I mean, I've already looked at some of your submissions for the infographic. I think they look great. So really it's about your, the cases that you're working on. I did have somebody ask me some questions about life insurance and understanding the difference between death benefit and cash value or market value of a life insurance policy. Anybody have questions on that they want to ask? And I don't remember what question you had asked earlier and if we really nailed it or not. I know I've used all of your blood sugar, and those of you that have a test with Cliff today, go enjoy some blueberries or something. What does it mean when it says tax implication? There we go. Tax implications of Max's death with regard to primary residence. So let's find that one. Where? We're talking about the, I want to make sure I'm seeing the same question that you are. Part 2, are we on part 2, question 1, Nick?
Yeah, except it's a different question.
Well, it's worded better on my screen. You may have downloaded the old version. I apologize because I improved it a bit. I made it more clear. Who will inherit the primary residence and what will the new, because what we're referring to when it says tax implications, we're referring to cost basis.
Oh, okay.
Sorry about that. I was a little confused.
That's okay.
All right, I'll stick around if anybody has any other questions. Otherwise, good luck for those of you who have more tests today.